to hold law enforcement, regulators and other authorities to account where we feel they got it wrong. And the Uyghur case was one example where we thought they got it wrong. And so we were fortunate to be in that instance, which I'm sure we wanted.
I'm Giles. I now work for Stop Traffic, an anti-human trafficking NGO based in the UK, but a global entity, and I can see some familiar faces in the room, so there are some friends here. I'm a former law enforcement professional. My last job was as Deputy Director for Intelligence with what is now the National Crime Agency, and I'm very interested in working with both this panel and also all of you going forward to help you understand more of lived experience translated for you.
Thank you. And my name is Lisa Clifford. I'm a barrister at financial crime. Can you hear me now? And I was also representing the World Legal Congress for some 6 years in relation to this case.
I'm Jonathan Grimes. I'm a partner at Predicate, and I'm just two roles relevant to this panel. First of all, I'm the MRO at Predicate, and I'm also a defense lawyer. So that's it. That's it.
Thank you so much, guys. Okay, Anita, would you like to kick off for us by just telling us about the Uyghur case in a nutshell? Nobody better to tell us about it than somebody who's working it for 6 years, so thank you.
Yes, absolutely. So just a really potted history. It started, as I say, 6 years ago. The Turkic minority people, the Uyghur people in China, in Xinjiang province, long been oppressed, well documented. They have been subject to forced labour for many, many years. What kicked this case off was that they were particularly interested in looking at the investigation of cotton products coming into the UK. And what it started with was first looking at a piece of legislation under the Border and Customs and Controls Act and looking at whether those products could be seized. But then there was also an idea, that pretty simple idea, that perhaps those same products could well engage proceeds of crime legislation. And then that then led to a request to investigate money laundering sent through to the NCA. And if we fast forward, following really lots of pieces of rather clumsy correspondence, that investigation request was refused. But rather than being refused for the fact that the NCA didn't have any resources to investigate it, it was refused for two reasons. First, it was said, well, in terms of criminal investigation of money laundering, you shouldn't really be asking us to investigate when you haven't even identified products on the docks of Tilbury, basically, which you say come from forced labour. So that was point one. Point two, which is more interesting from an AML compliance point of view, is what they said, well, obviously if products have come into the UK, they would have been purchased for adequate consideration, which is a bit of a term of art in the Proceeds of Crime Act. But in short, if you're paying money for those products, that breaks the chain in terms of it being criminal property. And so over the course of some 5 years, we then litigated that. And it led us down a really weird and wonderful world as to what adequate consideration means, which perhaps shows how boring I am. But what it ended up with from a really practical point of view is that, and this is in the Court of Appeal last year, which settled this, was that even if products and goods are purchased with money or adequate consideration, it doesn't in fact change the status of that property. So the high level point is, if a product is from forced labour, then that could be criminal property. And whilst the person or the bank or the company dealing with the product or indeed the proceeds would have an exemption from committing an offence of possessing criminal property, which is where this term of art, adequate consideration, sits, that term of art doesn't exist in any of the other offences of money laundering. And so when you move it, when you're in an arrangement to do anything with it, because that exemption doesn't exist there, you could have a money laundering problem. So that's sort of the legal implication. If I can just, I suppose, give you a little example, if that works, because sometimes that case gets talked about a lot, but actually in terms of the practicalities of it, it can be a little bit difficult to understand. But if, say I'm a company which is Belts R Us, and I operate here in the UK, and I sell my belts on Oxford Street. But as part of my supply chain, I source my belts from manufacturer in Turkey, and those belts go to the distributor in Italy before they make their way to Belts R Us here on Oxford Street. Now, I might have a bank in the UK, which I bank with on behalf of my company, but if I come across or I'm noticed, or have any reason to suspect, or indeed worse, know, that the manufacturer in Turkey is involved in forced labour in the production of my belts, then when those belts come here, or when they're transported here, if others in that chain have the same awareness, they've got a money laundering problem. And if my bank finds out, or say those allegations of forced labour are in the press, or there's any reason to think, gosh, that corporate client of mine might have an issue with their supply chain, which borders on criminality, then my bank will be concerned about a potential money laundering problem. So that is just a really potted history of the case and why it potentially matters.
Thank you, that's great. I suppose the next question that we'll cover is, it looks at first glance like a unique set of facts, but I think it would be nice to hear maybe from you as to why this is an important case from a societal perspective, and why we as a financial services community and the industry more widely should take note.
Sure, thanks. And I found that explanation particularly illuminating too. A quick bit of history. When I first bumped into someone talking about the issue of what we now describe as slavery in this country, I was a senior person in law enforcement with the ability to have some influence on strategic direction of the national organisation. And human trafficking was not a priority for law enforcement in 2008. And so we began a journey to make it one. That's 17 years ago. And quite frankly, the journey from that point to this conversation now has been one of slow learning. And to be honest, the UK, in terms of compliance with financial services, is mostly in what I would describe as a slow lane. But it's speeding up. In truth, there are things like this issue popping up. There's much more visibility. There's much more data out there that's finding its way into compliance systems. It's going to make it difficult to ignore. And in other parts of the world, in conversations with kind of mid-size American banks that bank particularly across the USA and sometimes externally, they have human trafficking investigators in their compliance teams and numbers of them. And I can't find that anywhere in the UK. So the place is on a journey, and there are lots of implications for us. Another quick example is when the US Customs and Border Protection Service seized a number of containers of palm oil that had been produced in Malaysia on a plantation at a factory where there was forced labour. And that made some very large international corporates whose factories needed that material quite urgently very grumpy. And it cost them millions of dollars to remediate that in a very short period of time. And these things will pop up more routinely as the availability of data and the interest from law enforcement, particularly from the US, however uncomfortable that sometimes is. I do think that there is the smell of a change out there, and when that happens, it sometimes hurts. You can think of Deutsche Bank and JP Morgan Chase still recovering from the Epstein saga. And again, that hurt them very badly.
Yeah, and Neil, I suppose thinking about human trafficking, modern slavery, and forced labour more widely, we need to remember that those are what we might call predicate offences, which in this country always give rise to a benefit. Predicate offences which give rise to a benefit always attract a proper obligation. And so I think the point here, I suppose, for you guys is that you're seeing that in the supply chain and that we need to be mindful of that as an industry.
Yeah, just the way we're seeing it routinely from our beds and cases literally popping up on a monthly basis, and it will become a routine. And we are reporting to those who amongst you are in receipt of that reporting and interested in receiving it. Every penny generated by human trafficking and exploitation that hits financial payment systems is money laundering. And there are very low levels of reporting to the NTA in this country.
Helen, Spotlight intervened to ensure that the NCA was exercising its powers appropriately. Do you want to talk us through that?
Thanks, Ruth. So I would say just up front, for a small organisation, a charity like ourselves at Spotlight, to intervene in a case, we work on a shoestring budget. So just at the outset, I'd like to have a huge shout out to the amazing team at Pinkley Napoli who supported us pro bono to intervene in this case, and our counsel, Henry Talbot. So really top class team that made that possible. But we were very grateful to have the opportunity to intervene, and really our concern was about the general principles that Anita's outlined, which the NCA seemed to buy into in their correspondence, and the High Court seemed to affirm. We were really concerned about the implications of that for our broader work, and we obviously mostly work on the predicate offences that are corruption and bribery related, but also the broader legislative regime in the UK for fighting money laundering, poker and indeed the money laundering regulations. And just to touch on the kind of two issues that Anita's pointed to, the one around the evidential threshold for beginning an investigation, and the second around this adequate consideration exemption. I'd like to tease out briefly why we were concerned about those and how they play out in the context of corruption and money laundering. So firstly, on the evidential threshold, we were really concerned that this would tie law enforcement's hands to really begin investigations in the kinds of cases that we follow, where we actually see the exact opposite. We so often have seen, particularly in civil recovery cases under poker, that law enforcement in fact starts an investigation with little more than a SAR that's been filed by a bank to really kickstart things. It shows how valuable the work that they're going to do. And even at times, at the end of an investigation that has been successful, law enforcement still isn't able to actually pinpoint exactly what the predicate offence was, the concrete offence by particular people in specific circumstances. So just by way of example, we've followed closely the Azerbaijani laundromat cases. That was $2 billion siphoned out of Azerbaijan using just a handful of UK shell companies. And the National Crime Agency has pursued the proceeds of that corruption that ended up in the UK. And in one case, for example, they managed to obtain account forfeiture orders of over £5 million in circumstances where they said there could be six or seven possible offences underlying the money laundering. It could have been theft, embezzlement, corruption, tax evasion. But they convinced the court that the funds moved in a way that bore all the hallmarks of money laundering, and that was sufficient to meet the threshold for forfeiture of those assets. So that shows that even at the end, they couldn't meet the bar that the NCA allegedly had said needed to be met at the outset, that you need to identify the particular property and the offending by particular people. So that was the one concern. The other concern was really about the adequate consideration exemption and how that plays out in the context that we work in. In particular, this idea that it acts as a circuit breaker to cleanse property tainted by corruption, and so on the one hand break off potential criminal liability for money laundering, but also to close off the possibility of recovering those assets. And so for us, we had a real concern that would actually disincentivize due diligence. If there isn't a prospect of liability and there's going to be no asset recovery, what is the incentive to actually do diligence on that? And for us as well, the problem with that is that it really cuts off for law enforcement a vital source of intelligence. SARS are really, really keen for so many investigations that they start and building that intelligence culture. So that was why we intervened, and I think, for us it shows that SARS in supply chain issues may shine a light on one isolated part of the transaction, but for law enforcement that can shed light on a much, much bigger, particularly in the context of cross-border corruption, much bigger picture of offending that they might want to be investigating. So it can be really, really valuable.
Thanks very much. Jonathan, I'm going to come to you next. I think, for this audience, it would be useful to talk about what would the implications be for financial services firms. So for those who may be banking or doing payments on behalf of Bells R Us, those who perhaps see a media reports and adverse news about supply chain issues, it'd be really useful to have some practical guidance for MLROs, nominated officers, and the second line more generally, as to what should they be doing, what should they be thinking about, what do the regulators say about this, how should they approach this question of supply chain due diligence in that context?
Sure, very happy to see that. So I'm going to dumb it down a little bit. As Helen said, my firm was part of the case, but I wasn't part of the case. I was just the MLRO who received judgment at the end and then had to try to figure out what that meant in terms of the work we do. So I'm going to dumb it down even further. I don't know if anyone here has seen the movie The Hurt Locker. It's a movie about a bomb disposal expert in Iraq who goes around using an unbelievable number of bombs. Very exciting. And there's one scene in it where he's being congratulated by a very senior officer, and the senior officer says to him, what is the best way to go about diffusing one of these things? And Footsbash comes back and says, the way where you don't die. And I think that has sort of application to my role as an MLRO officer. Hopefully not quite so dramatic, but asking a sort of similar question, you might say, what is the best way to perform your role as an MLRO? And the answer is the way where you don't go to jail. So all of my advice is based on that very low threshold of where would you get to. So in answer to your question, how should we go about fulfilling our obligations, and perhaps what does the FCA say about how we should go about it? And of course, what the FCA says is that we should, all regulated firms should apply the money laundering regulations to the way that they do their business. And what that means in practice is, from the outset, we need to be making sure that we have understood the risks which may arise in the type of business that we do, the kind of customers we have, the kind of geographies that we're dealing with, and that is your starting framework. And that hopefully will give you a bit of insight into whether you're likely to be having customers or situations which could engage in situations, issues like modern slavery. And then you move on to the more specific question of what do I make of this customer? How do I go about the kind of diligence? And fundamentally, that requires us to follow the evidence. And I always think that MLROs or people performing these types of roles, you need to have an inquisitive nature and a slightly sceptical attitude. That isn't to say that you have to go digging around endlessly, but what we're looking for when we're onboarding customers is we're looking at these different bits of information from the customer, from the databases that we use, from the adverse news trackers, and we're seeing do they tally? Are there any red flags that come up from this? Is there anything here that warrants further investigation? And if there is, then and I think this case doesn't really change that. If there is, then going back to my starting point, if you don't want to go to jail, then you're going to follow up on those things. There is no world that I can see, and I should say that I wear these two hats. I perform the role myself, but also I advise MLROs, and I've been involved in lots of situations where it hasn't quite worked. There's been some kind of difficulty, and I'm quite confident that we know for a fact that our jails are not full of MLROs, and largely that's because MLROs are diligent in the way they do their work. And I think there is no appetite in law enforcement to go after MROs who apply themselves diligently and in good faith in trying to interpret the rules, the regulations, the guidance, in reaching the right decision on judgments. And what MROs do the whole time is to try to reach a judgment, often that is not straightforward, often which will not have a definite right or wrong answer. And I'm confident that if that is done in good faith and with reasonable diligence, then probably all I was going to say, rather than getting into the details, I think it's so specific to any particular situation.
Yeah, and I think we've talked before about the fact of red flags for forced labour, human trafficking, and slavery having a lot of overlap with other red flags. I mean, there is some specificity around how you can identify human trafficking and slavery with regard to kind of transaction monitoring and how you might uncover that specific criminality. But generally speaking, the red flags that you might see for money laundering that you would already be training your staff on, you would be sort of setting parameters for and trying to identify. I don't necessarily know that there's, but I think there's a good read across between those red flags and the red flags that you might apply for a human trafficking and lens. So I think that it's not necessarily about doing a huge amount extra. It's about being alive to that, and particularly I would say probably within the first views and at the stage of searching for adverse news and negative media about supply chain issues. I think it'd be good to hear from you, Helen, on the advantages of doing due diligence more widely. So, I mean, obviously we talk about it in terms of compliance with the regulations, but is there anything you would say on that from your perspective?
Thanks, Ruth. I'll try and raise the bar from not only up in jail to some of the more positive benefits of doing due diligence. I think at the outset it is right to say doing due diligence is probably the best defense against criminal liability. So undoubtedly, from a very defensive nation, that is ultimately what's at stake, and I think very valuable. In terms of just the implications of the Uyghur decision specifically, I think doing due diligence is probably the best way you can show you received property in good faith as well. So it's a kind of good sign that you've done what you can. I think it would be very hard to argue that it would be in the public interest for law enforcement to prosecute in those circumstances. So that's reassuring. But I think more broadly and more positively, I think due diligence is increasingly a priority for shareholders and investors in companies who really want to know what due diligence and care about what due diligence is done on supply chain issues. We're seeing a rise in the number of claims that are being brought by investors against companies about that issue, and not only what due diligence, but also when there are suspicions, how they deal with those suspicions in terms of referrals. So, for instance, a case that we followed in the courts a couple of years ago, Glencore, the commodities firm was prosecuted for bribery, pled guilty, had to pay £280 million in financial penalties in the UK, but also faces a range of litigation claims by investors about that same underlying conduct. So it can show that actually the risks are on different fronts, and I think one needs to be aware of that. But then more positively, I think increasingly the kind of ethical and reputational dimension is very important about this issue. It's not only about fending off potential enforcement and regulatory action, but also about the broader range of stakeholders who care about this. So increasingly it might be consumers who really are asking these questions about where the products they buy come from and how they've been produced, but also folk like us, NGOs, campaigners, investigative journalists who are asking those difficult questions sometimes. And I think it's important to recognise that there's a much broader picture there about what those concerns are and how they might be brought to public attention. So I think there's a positive there, and I think it makes sense to take an integrated approach where you don't just kind of say, well, let's do the minimum that's required to kind of fend off the criminal side or the regulatory side, but actually say you take an integrated approach to kind of the anti-bribery and corruption issues as well as ESG more broadly, because you can get a better, more coherent picture when you do those together. So yeah, hopefully those are. Hopefully I'm preaching to the choir in this room, but yeah, I think I am. But just to reaffirm that I think it's incredibly important work and has consequences that are beyond just protecting one's reputation as a company from regulatory action, but really making sure you are positively contributing to an ethical and responsible business. I think it's super important.
Just going to very quickly add to that, there's a second lens, I think, through which you should look at this issue. And the only reason anyone has forced labour in their workforce is to make more money than an honest company that's paying its people properly. So margins are an aspect, a clue for you to consider. Trafficking and exploitation is just about making money. And if you're a business making more money than those that you compete with, and actually by you asking better questions, more questions, and disincentivizing bad actor access to financial systems in all their guises, you actually make a contribution to a reduction in the market for exploited people. So that's the win-win from my agitator's side of the equation.
Interesting. I actually, just off the back of that, I'm going to come to Anita next, because we all know that under POCA, you've got if you fail to report your suspicions, then the ultimate sanctions, you might go to jail. You're not accountable unless you are suspicious or you have objective reason to be suspicious. And so if you don't develop a suspicion, depending on how reasonable that is for you not to have developed it, then you may well be off the hook. And so I have heard it said, not necessarily credibly, but I have heard it said, well, why should we do our due diligence? Why doesn't this judgment disincentivize due diligence, actually? Should we not stop looking? Because if we don't look, we don't find, we don't become suspicious. Actually, like, what is it you want us to do, government? Because on the one hand, you're telling us, growth agenda, and there are competing priorities here, and it would be useful, Anita, to hear from you as to whether or not you think there's any sort of mileage in companies thinking, well, actually, let's step off the due diligence, train here, because it's only going to get us more, give us more headaches.
Yeah, definitely. I certainly think there is a massive temptation to bury one's head in the sand in order to then not be saddled with the mens rea or the trigger that the court, given how low the threshold is. So I completely see that. And I also completely see the point that has been made. Well, POCA really has no place in trying to encourage supply chain due diligence. There's a whole other piece of infrastructure out there which is designed to do that, built up over decades. What is POCA's place in doing that? But to all of those who say that, I suppose the UK is also being said lags behind other jurisdictions when it comes to supply chain due diligence and requirements there. And perhaps that's why, for our clients, that the We the People, and particularly the NGO that represented them, they had to resort to POCA because we didn't have at that time, 4 or 5 years ago, much in the way of legislation, even now, banning imports coming from Xinjiang. And not much appetite to really look at it under the guise of customs legislation and so forth. So that's why POCA entered the frame. I think because so many jurisdictions, including the UK increasingly, are only doing more and more in terms of supply chain due diligence, corporate social responsibility, that is a highly developed piece which is only becoming more developed. I think for companies, whether they're in the regulated sector or out of the regulated sector here, to say, well, we're going to close our eyes to all of that and take a different course. Wearing my own criminal defence hat, or indeed prosecutor's hat, I mean, deliberately closing one's eyes or changing practices or not asking questions when there are red flags or there has been something in the press that really ought to have been investigated. Sort of taking a different course to your peers and others in the industry, our competitors. I mean, that too could be circumstantial evidence. Oh, well, maybe there is grounds to suspect that you're just choosing not to see them. And I wouldn't take that chance, actually, if I was in an RO.
Thank you. And we'll come on to talking about tailing it down and suspicious activity reporting in a moment. But I think, Jonathan, useful to hear from you on the role of ongoing monitoring in existing relationships. So the sorts of things that firms can be doing to proactively identify supply chain issues, and also maybe thinking about sort of reactively, what might firms do if they get put on notice, whether in the press or perhaps more pertinently if they are written to by those seeking to highlight abuses, human rights issues, also in the supply chain. What should firms do?
Sure. And I think the first thing to say is that a lot of firms do a great job of onboarding and then do a less good job of ongoing monitoring for every reason in the world, whether it's to do with the technology. We're all very good at starting with the right framework and making sure everyone goes through the right process, but less good at putting a good system in place. So it is something you certainly see quite often. And what typically happens, in my experience, is that there may be particular categories of customers who get put into an ongoing monitoring type of pattern because of something, some kind of red flag or some kind of heightened risk which is identified at the outset. But that doesn't cater for the situation where at least adverse news comes up, which is next step where there's no particular screening tool or process to identify that. So I think that is it's definitely an area for particular vigilance and to always look at, and also to consider in your risk assessment generally. I think in terms of what you do, if you do have a system and you identify something like that, then I think everything that we've said so far, there's a consistent message that none of us think that ignoring it, pretending it doesn't exist, or anything like that, it must be the right way to deal with it. As we're talking about the potential reputational harm, unfortunate aspects, the legal risk. There's when I'm advising organisations about self-reporting and things like that, you're always thinking about, well, is there a whistleblower, someone who's going to bring this to your attention as well. So I think the two things I'd say is this is a weakness. Make sure that you address that and consider it in your risk assessment of your organisation. And simply, just as people have said, that if something does come up, you just have to illustrate that. You have to. These things are not. We'll talk a little bit about between red flag and suspicion. These are not binary decisions on the whole. It's iterative. It's kind of finding out a little bit more, asking some more questions, and that's something that I think there'll be endless forgiveness for making judgment which are wrong in that process.
Appreciate you've recorded it.
That's the evidence that you'll need.
Been saying that for 20 years, but okay. All right. Well, let's stay with suspicion. Actually, suspicious activity reporting and interim judgment. How does this judgment impact when a firm might submit a request for a DAML? So you've talked about facilitating the acquisition of the proceeds of crime. Possessing is one thing, but facilitating, transferring, moving around, divesting yourself of property or funds, which may be a supply chain issue. What should firms be thinking about in that regard and how to approach the issue, and when should they tackle this issue? When should they be asking for consent?
Yeah, so I certainly think that for those who are in the regulated sector, first clocking the fact that a tainted supply chain, and I say supply chain, which could be tainted by this label of loss, but it indeed could be tainted by other things such as bribery, such as some environmental criminality. It's really any kind of criminal taint to that supply chain which engages potentially reasonable grounds to suspect criminal property has entered this country. And so in terms of notification SARS and people in the regulated sector, it's first clocking that it doesn't necessarily mean you're going to be rushing to submit a DAML, but at least potentially just looking at that issue and thinking, well, from a notification SAR point of view, is there something in my line of business which gives me reasonable grounds to suspect? In terms of timing, I mean, a lot of this is going to be really fact specific. I mean, obviously, if you're involved in any kind of transactional arrangement, for instance, with a corporate who there are allegations that they're implicated in some kind of tainted supply chain, you're going to be needing to consider doing that DAML and putting together the DAML before taking any transaction forward. I think that's quite an obvious point. With your notification style, where you're not necessarily on the pointy end of the transaction and you're not doing anything, the obligation could well still be engaged, and it could be engaged at any point, really, limited. But really, the key there is when there are reasonable grounds to suspect, which will be very case specific, you do it as soon as reasonably practical.
Jonathan, you need to add to that.
Well, I need to at the start, you kind of set out the kind of situation with the belts for us, whatever it was. You didn't really give the solution to what they should do. And I guess that what this case does, just bringing us back to the start, is create this real difficulty where if we've received something and we're suspicious we don't have any consideration, but the question is what can we do with those funds now that they're sitting in our pockets, and what is it? Well, as we always will, we need to use it to support the staff and all the rest of it. I don't know if we want to deal with that now, or I mean, so and again, I'm dumbing it right back down. As my very simplistic view is that it's really bonkers to think that consideration can only apply to the extent of it coming into our accounts, because we all have to use the money that we receive, never just acquire it and then it sits there. And I take great comfort, and again, this goes back to my Grace Jail point, that the CPF, the Crown Prosecution Service, has not changed its guidance on applicant consideration. So it still says that lawyers, accountants can take money on account even where they have suspicions about the source of those funds. And by extension, it must be right, therefore, that we need to receive funds that demonstrate consideration. And it seems to me it must still be right that you continue to use that in the normal course of business, or Nextstar, or whatever else you do with it. Now, it will be very practice specific, but I don't think that, well, I think given the lack of any sensible suggestions anyone's been able to come up with since the judgment came out, I'm taking the view that life remains the same as it was before. The CPS guidance remains the same as it was before. My professional guidance for the legal sector remains the same as it was before. So my view is it stays the same.
Thank you for that. I mean, I think I'm often bandied this statistic around. I think it's informative and instructive to remember that there have only been, and these are stats I got from the Home Office, so they naturally don't make that much sense, but there have been two prosecutions and 4 convictions of MLROs for Section 331 offences, so for failing to report ever in the history of the problem. So when you think about the risk to you as an MLRO or to your organisation for failing to report, the risk of the ultimate criminal sanction being used is still very, very low. But I think that the discomfort of being under scrutiny, which John alluded to, and I certainly would advise clients on previously, the discomfort of being under scrutiny by a regulator or law enforcement agency in and around your treatment or suspicions can be expensive and damaging and harmful. So worth keeping that in mind. I think just so finally, go to the questions in the end. I really encourage you to ask questions because it's a great panel. They're some fine minds here. We have great insight into this area. But before we do that, let me just ask Neil and Helen, what should corporates expect in the future? Is the Uyghur case a sign of things to come in terms of law enforcement and regulatory action? Or is it a one-off? Do you think it's going to lead to better corporate accountability, or will we see it received?
To kick that off. I mean, I think even if we adopt the view that nothing has changed legally, as Jonathan said, that actually we continue much the same on legal principles, I think this issue is higher on the agenda, on the radar, certainly for law enforcement and others. I think it's very interesting, for instance, that just in the last couple of weeks we've seen the fast fashion company Shein decide to abandon its listing in London. And I think that's really a very good example of a direct impact, actually, of this Court of Appeal decision in the Uyghur case. What happened there was the FCA actually approved the listing in London a couple of months ago, but evidence and a pre-action letter brought by a campaign group to the FCA, basically saying the FCA has a duty to prevent the proceeds of crime entering the UK, putting pressures and threatening legal action, has led to, at least in reports in the last couple of weeks, that actually it's Chinese regulators that have not given their approval to that. And the thinking there is that a potential court challenge of the kind that we've seen would be embarrassing for the Chinese government. So there's already a kind of impact that we're seeing. So it might not be changing the law, but it's changing the approach and the strategy. And I think that also points to what I think we can expect going forward, which is a lot more of this kind of scrutiny and testing, putting companies on notice, about evidence, asking difficult questions. And I think Jonathan's already alluded to this in relation to whistleblowers, but I think they are only increasingly a number of different triggers for being put on notice or having those difficult questions. So even just on the issue of whistleblowers, this is an active area of policy consideration at the moment about whether to introduce reforms that would incentivize whistleblowers to be coming forward with intelligence on corruption and economic crime issues, so actually rewarding corporate insiders for coming forward. So I think that's a live issue on the agenda, and I think it's only going to increase. But then beyond that, I would really mention some investors and shareholders, increasingly being concerned about this issue, consumers, NGOs, investigative journalists asking these questions. So I think just to share a little bit of what we do, we often submit dossiers to regulators and law enforcement where we think there are grounds to be investigating and looking into some of these issues, particularly around corruption in supply chains. And at the moment for us, one kind of key area where we think there's vulnerabilities around critical minerals. We're currently doing some work trying to look at where are the vulnerabilities and what due diligence is being done in that space. And I think particularly in the light of what's happening in the US with FTPA enforcement being scaled back, shall we say, even in the last couple of weeks, I think that is a space where there is vulnerability. And I think for us, in the work that we do, corruption in supply chains of critical minerals is a real threat to the integrity of a fair climate transition. And I think that's only going to increase on the agenda generally. So I think it's a space to work.
I'm going to be really fast. I support everything that Helen said. The NGO sector is now providing increasing quantities of material to authorities around the world to get them to look at key issues. That palm oil case I spoke about earlier was as a result of an NGO submission to US Customs and Border Protection, not anything emerging from intergovernmental. And that will only happen in increasing numbers.
Absolutely fascinating. Thank you so much. Thank you, panel. That's really great discussion. Anybody have any questions? We'd love to hear questions from the audience. Thanks, Ellen.
Thank you very much. Martin Woods, Anna Money. Nice to see you, Governor. Those who don't know, Neil Charles used to be my intended tutor lieutenant before I left to join the police and join banking. Can I just diverse slightly and help the audience and help people for the domestic trafficking piece? For those of you who aren't aware of this, if you want to buy a fridge or a bike or a wardrobe, you use Gumtree. If you want to get an erotic massage and a prostitute, you use Viva Street or Friday, I think it's called Friday Advertising, right? So I run reports in my firms, I'm always looking at who's paying Viva Street. And if somebody paying Viva Street lots of money, it isn't for one person. It's totally legitimate for an individual person to advertise their services, whatever they be, on Viva Street. But if you're paying thousands of Viva Street, and I've seen up to $250,000 from domestic accounts go to Viva Street, you're looking at human trafficking. And on the back of Baroness Casey's report this week about nationality being an issue, Metropolitan Police have said whenever they raid a brothel, they expect to find Romanian women working there who've been trafficked and Romanian people running that brothel. So if you see those combination of Romanian passports and you see people paying Viva Street, you see cash being paid at post offices all over the country, you're looking at trafficking. And what the traffickers do is they break it down. If you put all of it together, any of us in this room could spot it. So they break the accounts up. But please, please, please keep your eye out for vast payments in Viva Street. Imagine, if you will, you're a trafficked woman and you wake up tomorrow morning, what's your day ahead of you? It is the most heinous crime imaginable. So if I've imparted something to some of you that weren't aware of that, I've done a good day's work. I'm not going to go home, I'll take my panel, but let me just leave that with you.
Thank you, Martin. And I think the human trafficking, modern slavery piece is, it's something that certainly the Institute is very interested in developing and working with the industry to try and raise the profile of that. And there's a big piece of work they want to do in Stop Trafficking, the Institute on human trafficking, modern slavery, and it's looking at raising awareness of red flags and exactly, Martin, as you explained, the sorts of features which absolutely blew my mind when I was learning about them, the sorts of features on an account which, when layered over one another, could give rise to, if you ran them through your systems and came back with your reports, you would be able to identify people who are actively engaged in human trafficking, and that's an exciting thing to be able to think about doing in this industry to make a difference to those people who, Martin, you say are, very, have a terrible life. So, expect more from the Institute on that. Lily, you have a question. Thank you.
Thanks very much. And it's a panel of rock stars in the human trafficking world. Thank you very much. And you mentioned earlier the reasons behind NC's decision not to prosecute the investigation. And progressing with the investigation perhaps might be the source, the adequate investigation argument seems to, or at least the way the NCA used it, seems to defeat the purpose of anti-financial crime, because the industry is expected to look at the picture, visiting sanctions. If you're looking to engage in a trade finance transaction with a Swiss commodity trader who is buying a commodity from a company in the form of origin, you do need to look at the picture in the supply chain. And so I do wonder whether perhaps in regards to the reasoning in NCA's decision, political concerns that you mentioned having relationship with China, but also the questions around the effectiveness of controls within the public sector, the state controls sector. As we know, cotton is being imported into the US, into the state controlled parts of the industry, and if you think there may be a reason around that, the strengths in most of those controls, do you think the litigation has actually driven some meaningful changes? We have seen guidance to the public sector empowering state-controlled companies to reject suppliers, which is interesting, right? Because the industry has always had that avenue. You can reject suppliers and receive issues. So I wonder what you think is on changes.
I certainly think our case, which took on a life of its own really unexpectedly, has contributed to change. I don't think it's been a driving force because, we went into the High Court and also the Court of Appeal against the background of a very large body of evidence, some from international sources, but also domestically, including parliamentary evidence, where there was a settled body of evidence to say there was forced labour happening in Xinjiang province, which definitely assisted us. And that was a common ground position. I think since the case, I have seen more activity. I'm certainly aware of more sort of JR type challenges around those same issues. So I hope we've had a little bit of a role in that. But I wouldn't be so arrogant to say that we've had major meaningful change against the whole background, all that very well documented evidence.
Thanks everybody. I hate to stand between you and your lunch, so I'm going to release you if I may. If you have questions and you didn't get to ask them, please approach the panel, come and see us, talk to us, join us on LinkedIn, any of that stuff. We'd love to hear from you, but for now, it's late for lunch and I think it'd be nice to have something to eat. So thank you.
Yeah, so we just finished heading for lunch now. So if you have any questions, just put it down in the chat. I should be able to ask some of the industry experts. So yes, catch you guys later after the break.
Yeah.